The big news of the day is Derek Chauvin. Now, if you've been following this channel for some time, you know that we've done a lot of deep dives on this case. Every single day of the trial, we were here with clips analyzing all of the direct examination, the cross-examination, the expert witnesses, and we've sort of taken the trial apart multiple different ways, analyzed it. I've gone on shows and been interviewed. People have come on our show and been interviewed, and we've really sunk our teeth into this case. Now we're just getting to the closure of it, at least for the lower level court proceedings. Now there's going to be appeals and post-conviction relief motions and all sorts of stuff that I'm going to guess happens later down the road. Right now what we're talking about what happened in the lower level court for a felony offense in the case of Derek Chauvin, confirmed now, convicted for killing George Floyd. And a lot of this has been a long time coming. This happened over a year ago. Finally today, many people are recognizing that this case is coming to a close or are considering it now done and closed. And so this morning, if we took a look at the court docket, we noticed that the sentencing hearing in the case was in fact scheduled for today. And so we're going to go through it. I have some clips from Judge Cahill. He spoke only for about 4 minutes, very, very brief sentencing, because what he said is that I'm going to explain it all in a very long memo. It's called the sentencing memorandum. It's 22 pages. And he says, rather than me trying to sort of flub my way through this, I really organized my thoughts and I got them down on a memo. And so we're going to go through a couple clips from the trial, from the sentencing proceeding today, and then spend a little bit more time in the trial memo so we can unravel what was going on here. Because if you've been following our channel, you know that as we were watching the evidence come into court against Derek Chauvin for the killing of George Floyd, we were identifying, and I'm a criminal defense lawyer, okay, this is kind of my wheelhouse, all sorts of reasonable doubt. And I've gone through the litany time and again. I'm not going to do that here. But what I did do is, much like Judge Cahill, this morning I got my thoughts organized a little bit on watchingthewatchers.locals.com. And so to frame out what I was thinking about 7 o'clock this morning, I want to just go through it briefly. I'm not going to read it verbatim, but I want to show you sort of where I was starting the morning. So we know that he was being sentenced today, 1:30. I said, watch it on YouTube. Defense attorney, Eric Nelson. Okay, we spent a lot of time with him. He was asking for probation, which basically means they're asking for Chauvin to just get out of jail, right? He's done. Just give him probation. He learned his lesson. That's all he needs. The prosecution, however, asked for 30 years, which would be the standard maximum. So for a recap, we talked about Judge Nelson. I'm sorry, that's not right. It would be Judge Cahill finding aggravating factors here, and we talked about that. I linked that up on a different video. We spent some time talking about that here on the show. Specifically, remember, when we talk about sentencing, what we will ordinarily do is kind of start in the middle. We say, okay, let's bring everybody who's been charged with, let's say, DUI, or let's say aggravated assault, which would be a more felony level offense in Arizona, and we're going to bring them all in front of the court, and we're going to say, okay, you've got person A, person B, person C. We're going to start them all at the same starting line. Then we're going to take person A, B, and C, and we're going to sort of look literally at a chart. We call them sentencing charts or sentencing guidelines. We take that person and we sort of look at their criminal history. We look at some of their mitigating factors, some of their aggravating factors, and we just kind of move them around in the chart. We say, okay, this is a class 4 felony. That's a class 4 felony. This person's a category 3 offender because they've got criminal history. We go, ding, 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 over here. And we look at that range. And within that range, you'll see different types of sentences, and specifically what I'm talking about is time in prison. So this will mean that we'll start at what's called the presumptive sentence. We'll start right in the middle and we'll say everybody, A, B, and C, they all start here. But A, he's got no criminal history, B has a little bit of criminal history, and C's got a ton of criminal history. And so now, based on that criminal history or some of those different variables, those permutations for each one of those individuals, now we can start moving them around the different boxes in the sentencing charts. And so we know that there are different frameworks for deciding whether to move somebody up in severity to aggravate the penalty or to minimize it, to mitigate it and work it down the other direction. And so what Judge Cahill did is he came out and he said, I know that there's a lot of allegations surrounding the severity of this case. I'm going to look at the Minnesota statutes and I'm going to just sort of take what they say are the aggravating factors. I'm going to take Derek Chauvin's case and sort of apply it to those factors, and I'm going to see if they fit. If they do, then I'm going to consider those to be applicable, and that's going to move Derek Chauvin up in the sentencing box towards a more severe sentence. So we know that historically, already Cahill has found that there were aggravating factors. So we said it looks like the sentencing is going to move forward today. No new filings on the docket. And I said that sometimes these things can get bumped out. Sometimes you'll go in there, pre-sentence report will have some surprises and be a little bit squirrely. And so you'll want to ask for a continuance or something like that. I was not expecting that today because Cahill was a very, he's running a tight ship throughout the entirety of the trial. So I was expecting it to happen, and it did. We know that Eric Nelson, the defense lawyer, was asking for probation. I said, that's obviously out, right? That's never going to happen. But I'd say also, I think 30 years is also out. I said, so is 30-year max. I say technically it can go up to 40 years, but that would be an appealable issue, and I don't think that the prosecution was going to ask for that. They didn't. They asked for 30 years. So I said probation, no. 30 years, no. I don't think the judge is going to do that. I said I have no experience practicing in front of Judge Cahill, but watching him in trial, he seems pretty neutral. I guess that he tends towards the upper end of the sentencing range, but mitigates it slightly from the maximum due to Chauvin's time as an officer and some of Floyd's contributing conditions. Okay, so I was saying that when we're looking at those sentencing charts, that box, that said that Cahill would move Chauvin up in terms of severity, but then work it back down a little bit based on his time as an officer and his contributing condition, some of Floyd's contributing conditions. Now, I'll be honest, right? I want to hold myself accountable to my analysis. I did not see that anywhere in the sentencing memorandum, right? It was very much supporting his aggravation, but I also just want to make a note that he also didn't give him the max. Okay, so he's not going to go in there and say, yeah, but he's been an officer for so long without any prior history. He's got no criminal record. He didn't really go into the mitigation, but we know that he didn't give him the maximum, so he must have considered some mitigation. We just don't know specifically what it is. We are going to go through the memo, so we'll get there in a minute, but let's keep going on here just so we can see what I was thinking at the morning. It says, so keep in mind, there will be a lot of politicking in both directions once the sentence comes down. He needs to find something, I'm talking about Cahill, the judge, Cahill needs to find something that splits the outrage somewhat evenly. If he throws the max at Chauvin, 30 years, the police may resign en masse. If he is overly lenient, then it's going to be a conviction without a consequence. And there will be more problems everywhere, right? There would be, more riots and protests and a lot of angry people. So my ultimate analysis came in here. It says Chauvin, he's 45 years old. A 25-year sentence would mean he is out when he is 70. If Minnesota allows for early release, 2-for-1 programs, any other incentives, he may get out around 20 and would be mid-60s with plenty of life left. That feels like an even split. Larry David from Curb Your Enthusiasm and Seinfeld fame, he said, a good compromise is when both parties leave dissatisfied. We'll have plenty of that here probably. And so, this, of course, doesn't take into account any of the appeals or post-conviction reliefs. I said this is such a volatile trial, it is hard to see how any neutral judge can consider it to have been fair and impartial. I've gone through the litany of reasonable doubt. Don't need to do that again. But more simply, I wonder whether the pro-conviction crowd here, if they genuinely think that Derek Chauvin enjoyed the presumption of innocence in Minneapolis when the trial started on the day of opening arguments. Do they? Because he was certainly entitled to it. And if so, would they trade places with Chauvin in an instant, knowing that that fundamental right was being preserved? Would they be confident that the truth would come out in court? Probably not. I said, because it's a dog pile. The general response is, I would never do such a thing, is what they say. And that's exactly what Derek Chauvin said. You just didn't hear the words in court because he didn't take the stand, because he was exercising his right against self-incrimination. So, this was something that I kind of threw out there in the morning. We now know that the total verdict, or the total amount of time, is 22 and a half years. So pretty close right in there, right? And I think the judge kind of did it right in the middle, split it right down both sides. Didn't give him the max all the way up to 30, didn't give him anything close to probation, and is sort of, my analysis was between 20 and 25, more or less. Judge gave him 22 and a half, so I was pretty sort of happy with that analysis. Now let's go through and see what is taking place here. A little bit more background here. And let me just also clarify, I don't practice law in Minnesota, so I don't necessarily know what the statutes are. I was just thinking about this in terms of politics, right? And what does the judge need to do given the range? And so if we sort of know what the range is, and you know what both parties are asking for, you can make somewhat of a prediction. And we know now that It's a decades-long sentence. Former officer was awaiting sentencing. There were concrete barriers, razor wire around the patrols at the courthouse during the trial. And it says still there was recognition of sentencing. Floyd died May 25th, 2020. He's facing a decade-long sentence in terms of Chauvin. And he's also got a trial on federal civil rights charges along with 3 other officers who have yet to state their trials. So we've got now, I want to show you the actual sentencing proceeding. So if you've never watched the sentencing, they can be pretty emotional. Obviously, there's a lot of people who will come in and explain why they have been harmed by the defendant. Jury has found factually that that person committed a crime. And now the question is, what was sort of the impact and some of the consequence? And so they'll bring, the victims in and the people who have been impacted by the defendant, and they'll just kind of, go up there for a few minutes and say whatever they're feeling. So we had a lot of that today. And we've got some pictures from a couple of the family members who came in. We're going to go through that. But before we do, I want to show you sort of I want to break up Judge Cahill's sentencing response. So he's only out for 4 minutes. And the first part of this is he's going to be telling us, he's going to be sort of addressing the public component of the case. He's going to be talking about, I'm sorry, that's not accurate. He's going to be talking to George Floyd's family and specifically addressing them while also sort of making note of some of the other public concerns. So he's talking to the family, but then he's saying, also other people in the community and elsewhere. So he's sort of, he doesn't want to go on the record much, only 4 minutes, because as we're going to hear, he explains this as saying, I'm going to leave most of it in writing. But he made a pretty important point to actually make sure that he made a statement to the Floyd family because of his belief, right? This is the judge. This is what he thinks is appropriate to do. And so I think that is sort of in alignment with the ultimate sentence, right? He's not happy with what he saw Derek Chauvin do. So let's go in. We're going to watch the first part of the sentencing. Then we're going to watch the second part of the sentencing, which is where he goes into the specifics, and you'll see sort of a side by side of Chauvin and Cahill. So here is Judge Cahill now, explaining why he is going to be sentencing the way that he is.
I have reviewed the pre-sentence investigation and carefully considered all the facts of the case and the law, but my comments are actually going to be very brief because most of it's going to be in writing. I have a 22-page memorandum that is going to be attached to the sentencing order. And why am I doing it in writing? To emphasize the fact that determining the appropriate sentence in any case, and in this case, is a legal analysis. It's applying the rule of law to the facts of an individual and specific case. And that is why, as opposed to trying to being profound here on the record, I prefer that you read the legal analysis that explains how I determined the sentence in this case. What the case is, or what the sentence is not based on, is emotion or sympathy. But at the same time, I want to acknowledge the deep and tremendous pain that all the families are feeling, especially the Floyd family. You have our sympathies. And I acknowledge and hear the pain that you are feeling. I acknowledge the pain not only of those in this courtroom, but the Floyd family who are outside this courtroom and other members of the community. It has been painful throughout Hennepin County, throughout the state of Minnesota, and even the country. But most importantly, we need to recognize the pain of the Floyd family. I'm not going to attempt to be profound or clever, because it's not the appropriate time. I'm not basing my sentence also on public opinion. I'm not basing it on any attempt to send any messages. A trial court judge, the job of a trial court judge is to apply the law to specific facts and to deal with individual cases.
All right. So did you see Judge Cahill's facial expressions there when he says, I'm not making this for any public statement or anything. He kind of looks over to Nelson over there. So he addresses Floyd. He's looking one direction. Floyd's family talking one direction, says, I'm not doing this for anybody else but me there, Nelson. Sort of like, making sure he knows this is not a political prosecution, a political sentencing or anything like that. But also, it's funny. It's sort of, these judges kind of will come out and they'll say, I don't want to be profound, but I also want to make a statement. So it's kind of having it both ways a little bit. But I mean, to be fair, I thought Judge Cahill was a very reasonable guy, and he sort of left this, 4 minutes, quick and easy. And we're going to spend more time going through the memo itself, but let's give a quick recap on some of the other people who spoke. We're not going to go through the videos because we've already really spent a lot of time on hearing from a lot of the people impacted. Obviously, we want to have empathy for the people who lost somebody. I know what it's like to lose somebody, and it's traumatic, right? The sentencing and criminal trials are like little nuclear bombs that go off for everybody, including the defendant, including their families. Everybody gets wrecked by these things. It is not a good thing. And so, I know that this case has been more weaponized and politicized than many others throughout that we've covered here. But I think there are always moments where you don't have to be, clawing each other eyeballs out. Something tragic happened here. Chauvin's life's ruined. Floyd's family's ruined. Floyd's dead. The city of Minneapolis is in despair. Race relations, I'm not sure they've ever been worse in my lifetime than they are currently. We have all sorts of, domino effects about fundamental changes, happening in our schools and elsewhere. The whole thing has been a bomb that has had a domino effect that has permeated throughout the country. It's very serious. It's very, it's very important. I know it's highly politicized, but for, a little bit, we can all just sort of put the pause button on that and just say, listen, man, this family lost a brother, and it's just it's a terrible thing. So here is Philonise Floyd. He's wiping tears away for an entire year. Had to relive George Floyd being murdered. Totally understand that, right? We got Floyd's brother, Terrence, tearfully gave his statement directed at Chauvin. Says, I want to know why. Why? What were you thinking? What was going through your head when you held your knee on my brother's neck? His nephew, Brandon Williams, to the right, said in his statement, Chauvin killed George. Not only did he kill George, but he also displayed a total lack of consideration for human life as he did so. Okay, so it's those types of statements. Very emotional, very angry, right? Obviously, they lost somebody who was close to them. So I can understand that, empathize with it completely, and I wish them genuinely a recovery in terms of dealing with their grief and hopefully moving beyond the situation. Not sure that that's possible when you have something like this going off. Now, something that was surprising is Derek Chauvin's mother was also there. So Chauvin's mother, Carolyn Palenti, made a surprise appearance at the sentencing. She said Chauvin is her favorite son, spoke of his innocence. She said Derek has played over and over in his head the events. I've seen it take a toll on him. I believe a lengthy sentence will not do him well. When you sentence my son, you'll also be sentencing me. Okay. And this is true. This has been my experience. A lot of the time, the defendant is not necessarily particularly upset, candidly, about what is happening because they know a little bit more about the case. They were there. They know what happened. They know what the maximum is. They know what they're getting. They know whether there's a deal or not and sort of what the risks versus reward analysis is. But oftentimes the family just doesn't. They just wake up. They go, I thought my son was a police officer for like 20 years. What are you talking about? What do you mean he was out doing his job? He was conducting an arrest. And this happened, right? And this is just a mom, right? Whose son just was a police officer like, 17 months ago. And now she's got to deal with it, not to mention everybody else. So it's a catastrophe. It's a terrible thing. And hopefully we learn something as a result of this. I'm not sure that we will, though. Now, here is Judge Cahill. This is the second half of his sentencing, where he is actually dictating what the term is, the full term of the time in prison. And so let's pick that back up.
And so, Mr. Chauvin, as to count one, based on the verdict of the jury, finding you guilty of unintentional second-degree murder while committing a felony under Minnesota Statute 609.19 subdivision 2 paren 1, it is the judgment of the court that you now stand convicted of that offense. Pursuant to Minnesota Statute section 609.04, counts 2 and 3 will remain unadjudicated as they are lesser offenses of count 1. As sentence for count 1, the court commits you to the custody of the Commissioner of Corrections for a period of 270 months. That's 270. That is a 10-year addition to the presumptive sentence of 150 months. This is based on your abuse of a position of trust and authority, and also the particular cruelty shown to George Floyd. You are granted credit for 199 days already served. Pay the mandatory surcharge of $78 to be paid from prison wages. You're prohibited from possessing firearms, ammunition, or explosives for the remainder of your life. Provide a DNA sample as required by law. Register as a predatory offender as required by law. And then you will receive a copy of the order and also the attached memorandum explaining the court's analysis. Anything further from the state?
If this needs to be said, we just ask that it be executed forthwith.
Defendant is remanded to the custody of the sheriff to be transported back to the DOC or whichever custody is currently holding him. Anything from the defense? All right. Thank you. We are adjourned.
There you have it. So that was it, right? That's it. Short time. Boom. 2 minutes each time. He clipped that all together into one 4-minute spiel, but that was it. That was the order from the judge. That was the sentence. So now Derek Chauvin is going to be getting 22 and a half years in prison. And so you see how he broke that up, right? He said that it's 120 months over the presumptive. So he said it or whatever, 150 months is the presumptive, and we're going to take it all the way up to 22 and a half because of the aggravating factors. He went through and he said basically what he saw there made it worse. We're not going to start at the middle, just like we had person A, B, and C. We're going to take that person C because it was so bad. Those factors mean that he deserves a worse or a harsher, more aggravated sentence. So 22 and a half years fell short of the 30 years that the prosecutors had requested. Came after Chauvin broke more than a year long of silence. With good behavior, Chauvin 45, he could get out on parole after serving 2/3 of his sentence, or about 15 years. So it's actually considerably more generous than even I was predicting, right? So from about 22 and a half down to 15. And so, when you see stuff like this, of course, there's sort of, especially when stuff is this high profile, you've got kind of two headlines that you can see. You've got the stuff that the public knows about. What do we see? We all see 22 and a half years in prison, right? What does Derek Chauvin and his defense attorney see? Well, they see the 15 years. They go, okay, so 2/3 here. If we can, maybe have an appealable issue down the line. Maybe we can, do something about that, whatever. So they're not looking at it as the 22 and a half. Now the public sees that. They're very happy about that. Wow, 22 years, that's a long time. And Chauvin really knows it's kind of about 2/3 of that. And so, the judge is sort of finessing both sides. He's making sure he's splitting the middle. He's saying, wow, we're going to show everybody what a very strong, serious, stiff penalty this is, knowing that about 1/3 of that is kind of not really going to be there. So now you have the other officer wing. Remember in my post this morning, I said you kind of got these two constituencies that you got to balance. You've got society and you've got law enforcement. Law enforcement is not particularly happy with how society has been treating them lately. We have officers who are just they don't want to be officers anymore. We're talking about these shortages all over the country. And so what Cahill did is kind of split it. And the police know, okay, 22 and a half, what does he do? 2/3 of that. So what, 15? Okay. So, that suddenly doesn't seem as bad as the 22 and a half, but the rest of society doesn't really know it's a 2/3 rule. So they look at it and says it's a big serious sentence. So everybody's happy. So it's a nice way to split the verdict. All right, so let's go into the order now. This is the memo that Judge Cahill was mentioning. It's 22 pages. We're not going to read through all of it. It was filed this afternoon out of Minnesota. Sentencing order and memo. Let's go through it quickly. As for sentence 1, we already heard this. 270 months. We've got 199 days already served credit. Surcharge, $78 he's got to pay. No firearms, right? So he's been convicted of a felony, so you lose your right to possess a firearm. Got to provide a DNA sample, register as a predatory offender, and in this memo, explains everything. Signed here by Judge Cahill. He says, for a defendant like Chauvin, he's got 0 criminal history points, so the guidelines give us that presumptive range, right? They go in the box, they pick out the presumptive, they start right in the middle. They say, okay, Chauvin was found guilty. That means we can go anywhere in the range and we can come up with 150 months. That's the starting line. That's where we all start. So what he's going to do, he's going to say, well, in the first stage, the jury must make a factual finding that there were more aggravating factors in the case. Then the district court has to explain it. So he's going to show us that he did this. He says at the first stage, well, we got the verdict. The verdict agreed to submit issues of aggravating factors, and the court came out and they found the same thing. And remember this, we talked about this here on the channel, and I linked the older video over in locals, but if you search on our current channel, you'll see where we did a deep dive on the aggravation memorandum that Judge Cahill drafted. But for a quick recap, he said in a prior motion or prior order that Chauvin abused a position of trust and authority, right? That's him being a police officer, that he treated George with particular cruelty. He also said that children were present and that Chauvin committed a crime as a group with other individuals, right? Those were the other officers, Thao, Thomas, Lane, and Alexander Kung. And so he's saying, okay, we got to identify the factors that are aggravators, and then I'm going to sort of weigh them in terms of increasing the sentence. So we start at the presumptive, the 150 months, and we're going to work our way up. So what factors, why did Judge Cahill give him 22 and a half years? Let's go through it. So he says, first of all, the dispositional and durational departures that Chauvin is requesting are not appropriate. He says Chauvin wants probation. Are you nuts? That is not going to happen. He says neither one of those is appropriate in this case. So we're just going to get that right out of the way. So at the starting line, we know that the prosecution is asking for the max. Well, Eric Nelson, the defense, is asking for the minimum. So he comes out and says probation. He's already been punished enough. He didn't do anything wrong. Give him probation. Let him out of custody. Make sure he doesn't break the law again. That's the end of it. Judge says, no, we're going to get rid of that right away. So that's gone. Don't even need to spend much time on that. Mr. Chauvin's abuse of a position of trust. Remember that second aggravating factor here? And authority, he says it's substantial and it's compelling to increase the severity. He says he was a licensed police officer from Minneapolis. He held a position of trust. The trust placed in the defendant included a trust that anyone arrested would be treated with respect. He says the court has already found that he abused his position of authority. He was putting him in he was using unreasonable force to keep him handcuffed, prone, and on the street. He said positional asphyxia for more than 9 minutes and 40 seconds was an inordinate amount of time. Also says, why was it an abuse? Why was it so compelling? He was placing his knee on the back of his neck. It was an egregious abuse of authority. It was prolonged. It was a maneuver that was employed after Floyd was already handcuffed and continued for more than 4.5 minutes after he had stopped talking and become unresponsive. This is Judge Cahill. Chauvin says, Mr. Chauvin, he says, abused his position by not rendering aid. He declined 2 suggestions from his fellow officers to put Floyd on his side. He prevented bystanders, including an off-duty Minneapolis firefighter, from assisting, which, you know, I know the prosecution made a big deal about that. And I think that was Genevieve Hansen who also made a big deal about that. But I'm not so sure that I actually agree with that one because, you know, she was a stranger. She wasn't in any uniform. So if somebody's running up to you at the side of a crime scene and is actually trying to interfere with your work, that is, I think, problematic. But I'm not going to go through point by point. We'll be here for 2 months. Okay, so enough of that. Sorry, Rob. Get back to it. Okay, number 4, the failure to render aid became particularly abusive after Floyd had passed out. So he didn't help him. He also says that Chauvin's treating George Floyd with particular cruelty is a good reason to make it more severe, to increase the severity of the penalty. What is he talking about? He says, against the overwhelming weight of the evidence, Chauvin argues that his conduct was not particularly cruel. He says because the assault of Floyd occurred in the course of a very short time. He says, and he also says it didn't involve any threats or taunting, but Cahill notes that this court has already concluded the assault occurred over an inordinate amount of time previously. Fellow officers, he said they were watching him sort of die slowly and that the prolonged nature of the asphyxiation was particularly cruel. Mr. Chauvin says doesn't identify any reason why this requires threats so he's going through some legal analysis here. Now, Judge was not happy about this, so I want to point this out. He says, the video evidence presented at trial captures Mr. Chauvin dismissively responding, at least a couple times in response to Mr. Floyd's pleas, and also commenting in response to his pleas, I can't breathe, that, quote, takes a heck of a lot of oxygen to say things. Judge did not like those little remarks at all. Put those in there. He continues, the presence of children at the scene, though, He says that's not going to be used as a substantial and compelling reason to increase the severity. He said, well, the first two aggravating factors, yeah, we found that, they exist, but here, under all the circumstances, this is not a reason for an upward durational departure. So when we're in the box, the fact that there were children there and the fact that the government actually called them in there, I think there was a 12-year-old, 14-year-old, and maybe some others, but they called them in there. Court said, well, yeah, that's true, but that does not by itself as an aggravating factor justify an increased, more severe penalty. Same story here. He says the actions being part of a group of other officers is also not being used as a reason for the increase in severity. So we've got sort of the two factors that were and the two factors that were not. In summation, we have here from Cahill that he did not plead guilty, but he cannot be punished by exercising his right to a trial, but he must be held accountable for the death. He did so in a manner that was particularly cruel and an abuse of his authority in consideration of all the facts presented at the trial and the court and this experience over the last 10 years. They find the appropriate prison time is 270 months. There it is. In conclusion, part of the mission at the Minneapolis PD is to give citizens voice and respect. Here, Chauvin, rather than pursuing the MPD mission, treated Floyd without respect and denied him the dignity owed to all human beings, and which he certainly would have extended to a neighbor or friend. In the court's view, 270 months, which amounts to an additional 10 years over the presumptive 150-month sentence, is appropriate sentence. Signed here, PAC, which I believe is Peter A. Cahill, and so that's the sentencing memo from Judge Cahill. A lot of time, not much mitigation in there. Didn't see any sort of working it down the other direction. But that's Judge Cahill's prerogative. Now, there was another motion that came out before the sentencing took place. And a lot of people had questions about this. Well, what about a new trial? What about prosecutorial misconduct? What about, some of these jurors who were doing some ridiculous things, like the juror number 52, I believe it was, who actually had a "get your knee off my neck" shirt on, attending a George Floyd rally. He said it wasn't a George Floyd rally, but it was a civil rights rally, so you can mince words about that. But then when he was called in front of the attorneys during voir dire, during jury selection, and they asked him, have you been to any rally at all? And he said, no, I have not. And there's pictures, and he's on a podcast talking about this stuff. So, well, doesn't that deserve a new trial? Shouldn't we do this all over again? Because how can anybody possibly conclude that Derek Chauvin got a fair and impartial trial, that he walked in on day one and had the presumption of innocence, when I think during jury selection, if my timeline's not mistaken, they even settled the civil claim for $27 million right in the middle of the case. Maxine Waters was ranting and raving about, they better come to a certain verdict. She parachuted in from California. So the whole thing was sort of a mess. Does that justify a new trial? And we saw some motions were submitted by the defense. We saw a response was filed by the prosecution. What did Judge Cahill say about any of that? Well, very simple. Denied as to all of them. The denying of the motion for the new trial and for the Schwartz hearing. So this came out, and you'll notice same motion. It says the matter came before the court. We got Eric Nelson, Matthew Frank, and the whole litany of people here. Based on the records, the court makes and finds the following. It says here, the defendant has failed to demonstrate that the court abused its discretion or committed error, that the defendant was deprived of his constitutional right to a fair trial. So, nope, no abuse of discretion here, no new trial. Also, the defendant failed to demonstrate that the state engaged in prosecutorial misconduct such that he was deprived of a constitutional right and that he gets a new trial. Nope, denied on that one too. And I think that was about some of the leaks that were taking place. Remember, early on, there was some allegation that there was a story that was leaked to the press about a plea deal involving Derek Chauvin and Attorney General Bill Barr back when Trump was still in office. And the allegation there was that if there is a public disclosure that the defendant is contemplating a plea deal, then that might make it seem that though that person is already accepting their guilt. And if jurors see that, well, then they're going to say, well, he was going to take a plea deal anyway, so he must be guilty. So I have no problem finding him guilty because he was going to plead guilty anyways. So was that a problem? No. The judge said, no, that wasn't a problem. Also says here that the defendant failed to establish a prima facie case of juror misconduct. Okay, so on its face, they're saying that the defendant, Chauvin, was not able to just show us, just kind of flatly and plainly, that there was juror misconduct, or that a juror gave false testimony during voir dire to warrant an evidentiary hearing pursuant to Schwartz, which is a Minnesota case that is, I guess, would remedy that problem. So now what we've got is 3 attempts to sort of do this over again or reopen the case. Judge Cahill is coming out and said, nope, they are all denied. So the defendant's motion for a new trial, denied. We have defendant's motion for a Schwartz hearing, denied. And if you want to take a look at any of this stuff, you can get a copy of the proceeding here in Exhibit A, signed off on, again, by Judge Cahill. And so it's mostly over for the Derek Chauvin case out of Minneapolis. Now, there'll be appeals. There'll be post-conviction relief motions. This whole thing is going to be kicked around there for a long time. We'll continue to follow it. But for the bulk of the underlying case, sentencing was it. Derek Chauvin's been remanded 270 months, a long time in custody. Let's see what you think about the sentencing today. Let's start off here by going to watchingthewatchers.locals.com. First up in the house is Want to Know says, welcome to hot and sunny Portland, hotter than Scottsdale, Arizona. A few snowflakes should melt. So how come Chauvin has to register as a predatory predator? I know Snow thinks they are. So I heard about that in Portland. Like, it's crazy hot up there. Maybe the heat dome that we had here that was melting Arizona just sort of moved up there to Portland. It's crazy what's happening here. But a predatory predator. So I'm not sure what the particular rule is. There are certain offenses where you have to sort of register on a list somewhere. So I think the most obvious one here would be sex crimes. You have to register as a sexual offender. But if you're somebody who maybe is as a domestic violence person, you may have a domestic violence designation on your record. You may have a weapons designation or something like that. So I can't speak specifically to what's happening in Minneapolis or in Minnesota, but probably something like that. If you're involved with a murder, you get labeled as a predator, right? Because you're somebody who took somebody else's life, is what I would guess. Justice First is here, says, Chauvin said, quote, other information in the future give you some peace of mind. It can't bring George Floyd back. The Floyd family already got money and harsh retribution for the accused. So do you think other information could be strong evidence that Chauvin did not mean ill will towards George Floyd, or that this ordeal resulted in some great good, like maybe prevented deadly drugs from reaching others' teens? It's a cliffhanger, but spells some hope for Chauvin. Yeah, it's a good inquiry. I don't really know. I didn't catch that. So other information in the future give you some peace of mind. Yeah, that's a good question. I don't really know what he's talking about. I'll have to go watch that again. I mean, off the top, it doesn't sound particularly like it was worth it if you're Derek Chauvin to go through that in order to prevent some drugs from hitting the streets. Maybe it is. Maybe if those drugs were fentanyl or something and they wiped out a busload of people, well, that would be for the greater good. But that seems awfully speculative. I'm not sure what that is about. It's a great catch though. Not sure what he was getting at. He says, Justice First says, I recall that you predicted Judge Cahill might split the difference between 40 and 0, which he did. Did you have insider information, or was this your own genius? No, I don't know. That's a good point. So you're actually giving me more credit than I was giving myself. But yeah, I mean, so I just took a stab at it, but it's more about politics. It's not necessarily, in this case, it's more about politics. Sometimes it's about legal maneuvering, but in this case, it was a whole different ball game. So I'm not sure that was any legal, expertise more than it was sort of knowing that the judge has this political posture and that he's got to sort of make a ruling that sort of makes both sides equally unhappy. And I think he did a great job with that. So thank you for noticing that though, Justice. Soledad Viking says, hey Rob, so all this accountability today with Chauvin, but they still never mentioned the delayed arrival of the EMS, their choice of going off site for treatment for an extended period of time, about an hour before going to the ER, no administration by EMS of Narcan when indicated, dispatch having made an error in sending fire to the wrong address. So those are great questions. Yeah, those are all great questions. One of them I think I can answer. So during the trial, EMS, when they did show up, they were saying specifically that they were a little bit concerned about the crowd, right? The crowd was very unruly at that point in time. And that was part of the actual defense for Chauvin. If you're in a position. My sort of argument there was, how do you explain Chauvin not administering aid? Well, you have to sort of default to something that the police say is legitimate. And so what would you sink your teeth into? How about something like securing the crime scene, right? How about officer safety? How about making sure that a situation doesn't devolve into chaos where more people can get injured and hurt? And so what you do is you maintain your perimeter. You establish force. You show your force. You make sure that everybody out there knows that you're in control until backup arrives. And so what you do then at that moment in time is sort of preserve status quo, make sure Floyd doesn't move, crowd doesn't get involved. You got 4 officers making sure, kind of securing the perimeter, waiting for EMS to get there. And when EMS did get there, that at that moment they said, at least in trial, there was one of the people testifying, one of the witnesses said something to that effect. It was very unruly. We knew that we couldn't render aid right there because of the volatility of the situation. So we loaded him up, went around the corner, and started administering CPR at that moment. So I think that was one of the answers to one of your questions, but the others are great. And I think your point is well taken, that there are a lot of other potentially contributory factors that may have significantly contributed to George Floyd's death beyond just the knee. We've talked about it. The methamphetamine use, the active amount of fentanyl that was in his system, the last minute ingestion theory that we heard a lot about, the heart problems, which were 90% closed according to the government's own witness. A lot of problems here, not to mention maybe some contributory negligence or something from EMS, or there's all sorts of different ways you could split this, but the jury didn't buy any of it. We've got Todd Trout says, we wonder what the backlash will be. Will many officers leave Minneapolis because they are led by poor leaders? Probably. Yeah, I mean, I would guess. I would think that you'll see the same trend that you're seeing elsewhere. I think I saw in Portland or Seattle up there that they're down. I think Seattle's down a few hundred. We just covered a story this week, if I'm not mistaken, it's out of Baltimore. They're down a few hundred officers. They're just, they're tired of it. If they don't get appreciated, why would they continue to do the work? I don't think anybody should do that. I mean, if you're capable of moving into a position where you are appreciated, I think everybody should strive for that. I know it's not possible for everybody, but that should be a goal. Work with a group of people that appreciate the work you do. And that also applies to police. I think that's just good sense generally. Sharon Quidney says, Chauvin didn't get a fair trial. He was a scapegoat, pure and simple. Same thing is happening to the people involved in January 6th. I believe the police just arrested some folks who were actually invited in by the police. That's going to be great. They are going to track down everybody involved, however peripherally. Now they're all branding all MAGA supporters white supremacists. Toto, I don't think we're in Kansas anymore. Yeah. Yeah, and we're going to get to the January 6th stuff because Nancy Pelosi just announced a new commission is coming up. That's for our last segment of the day, so we'll get there. We've got Jeremy says, I understand that many people think the citizens in Minneapolis are crazy or being ridiculous about how they think and feel about police. Unfortunately, they may actually believe they are being targeted. In my opinion, the false perception and the willingness to believe something so blatantly ridiculous is the real issue. This is coming over from Jeremy Matrita. Good to see you, Jeremy. Yeah, there is a lot of that, and I've criticized that as well. I typically will cover stories, about bad popo and things like that. And I'm a defense lawyer. That's the point of this channel, watching the watchers. But I also recognize that the pendulum is swinging to the point where it's becoming a little bit, sort of, I would say, out there, where I'm hearing from people that say, well, walking around is like as like police are going to murder you walking down the street or something like that. Like what happened to George Floyd is like a common thing that's happening all over America. And I'm going, that's not really the situation. Yes, there are deaths and killings, and there are situations where somebody is no longer with us who should still be with us. Absolutely. But if you're walking down the street, you don't see cops just, randomly mowing down black people or anybody to the degree that some people are making it out to be. Right there, it's happening. I'm not denying that it's happening. We cover a lot of them. We cover most of them on this channel. I get very irritated about it. But you also have to be reasonable when you're sort of characterizing anything that's happening in our country. And unfortunately, there's just not much of that going on. Everybody's saying everything's a nightmare. Either all the cops are white supremacists, or all the cops are, absolute heroes that don't deserve any oversight or accountability. I mean, both of those things are not right. So we have to find something in the middle. And I know that's complicated because everything is politically volatile these days. Hack Consulting is here, says the whole Chauvin thing is BS, just a bunch of political people trying to look apolitical, yet that apolitical crap is exactly what is highly political at this very moment. The whole trial is a crap fest. The people who are cruel are the Floyd family that testified, not Chauvin Kangaroo Court, trying to look legit. I've also made that point. What we're going to see here is a lot of people ran their mouths for 18 months about George Floyd and Derek Chauvin, mayors and politicians. And you can make the argument that even Joe Biden and Kamala Harris maybe got elected on the back of this stuff. We're going to come out there and demand justice. We're going to out there, we're fighting for true reform, meaningful reform, blah, blah, blah. Chauvin is sentenced. This whole thing is going to be swept under the rug. It already is. We're already talking about new crime bills and new crime enforcement stuff. Joe Biden just unlocked $350 billion of money that was already allocated for COVID for law enforcement now. Oh, here you go. Here, just take that. Just take that to get to pre-pandemic capacities. I've said this consistently. Joe Biden is very pro-police. He's somebody that wants more law enforcement officials out there, not less. He's got a long history of this. I played a video from 1985, 1989 yesterday, where he was talking about tripling what George Bush wanted. So, they don't do anything, is my point. They all come out there. They all get on, somebody gets killed. They all milk it. I think it's shameful what they do to the people who die. I think it's tarnishing their names. It's disrespectful to them. And they milk it for political gain. This whole thing caused a lot of division and animosity, and they're just going to sort of move on to the next topic. They're actually talking about, sort of refunding the police and actually integrating federal law enforcement agencies now on a local level. And you might think, oh, well, they're coming for the guns and the white supremacists because it's Joe Biden and Merrick Garland. That's not the case, my friends. They come after everybody. And unfortunately, we're all going to be left, holding paying the bill. All right. Boxy Punk Chick is here, says, what I do not understand is why they didn't bring up more than the fact that Chauvin knew Floyd was on something. He asked him if he was on anything. Of course, someone will lie about it. But when he said he couldn't breathe and already had the speculation that he was on something, he should have been a little bit quicker getting aid. Yeah, that's a good point. Yeah, and it was there was a moment when George Floyd was also complaining about not being able to breathe before anybody was even on his back, right? I played that clip. I put that clip up on Twitter. And so, you sort of have to balance a couple different factors. On the one hand, as a police officer, you've got to enforce the law. You've got to make sure you can conduct your arrest and get somebody under your control and not injure themselves or injure you or escape or any of those things. On the other side, though, you also have to sort of, recognize that you can't do that with an evaporation of your humanity. There's at some point where you can't treat people anymore with aggression. You have to treat them with a little bit more humanity and more empathy once you've already gotten control of the situation. So it's sort of like, in mixed martial arts, when you have somebody in a submission hold, you don't actually break their elbow. You don't actually rip their shoulder out of the socket or strangle them to death or knock them unconscious. You just, gotcha. Okay, you good now? All right. A little tap goes on. Or if you're somebody with, a little bit more experience, sometimes you'll let that person fight a little bit, right? It's okay. I've got total control of the situation. They can squirrel around whatever they want. They're not getting anywhere because I've got training. They don't. I know where they're going before they're going. And so if you're somebody with that training, which is often what we ascribe to police officers, as we should, they do have training. They go through a lot of it. They get paid for it and they get a lot of powers and responsibilities because of it. So in that situation, you want to make sure that that officer is not crossing that line. And of course, the jury and the judge found that Chauvin did. All right. Matridez here says, everything about this case is so disgusting and infuriating. These people are clearly nuts and they claim to see something that did not happen. People are entitled to their own opinion, but not entitled to change the facts. It's a good point, Jeremy. Good to see you. Last one in the house is from Joe Snow, says, Chauvin and a 22-month sentence. Oh, well, how many people's lives have been ruined by him? It's a good question. right? It's a good question. Who knows? Certainly George Floyd's family, certainly everything that sort of trickled out and emanated from that. You could make the argument is all attributable back to Chauvin. At least the jury did. Sounds like the judge may have done so as well. Now, I've been consistent here that I've said that I think that there were a lot of problems with this trial through and through. I've gone through the list of all of the reasonable doubt there. I'm not going to do that again. But this was a case, my friends. This was something that we spent a lot of time in on, and I appreciate you joining me as we've gone through it. I know I've learned a lot. Hope you did as well. Hopefully, you also never need to find yourself in a situation like Derek Chauvin. Never. Or anything not even nearly as serious. It could be something much minor. But if you do, well, our law firm can help. I want to show you the R&R Law Group. We can help with all sorts of criminal violations, things like felony, drug charges, traffic violations, DUIs. We can help clear up old criminal histories, old records. We can remove a mugshot off the internet or a handful of them if you've got that going on. Restore your right to vote. Help you get your ability to possess a firearm back if that's possible. There's a lot we can do to help nudge things back on the right track. You know, you have rights in this country. Many people just kind of give them up. We don't want to do that. So if you need help, or if you know somebody in the state of Arizona that needs help, we offer free case evaluations. We would love the opportunity to speak with your referrals. If you don't know anybody that has a criminal charge, that's okay. Maybe we want to keep it that way by ensuring that you don't incriminate yourself. The way to do that is by taking the law enforcement interaction training, which you can see down here. It's available on my Gumroad page. It's gumroad.com/Robert Gruler. Law enforcement interaction training is available now for your purchase. You can click or take a picture of this QR code if you want to take a link over there. Also, if you're an attorney or a legal professional, be sure to check out our legal mastermind, which is a ton of fun. Great questions. All of those came over from watchingthewatchers.locals.com. Thank you so much for your support. Really do appreciate all the love over there.